I would reserve 5 minutes for rebuttal.
Let's give everyone a chance to file out so we can.
I'm sorry.
You can have our undivided attention. Okay.
Thank you, Your Honor. As I said, 5 minutes, if you would. If it please the Court, I'm Stephen Warm. I represent the defendants, appellants in this matter. This was an action for a declaratory judgment on the construction and effect of what I would call a somewhat singular deed of homestead property. The grantor conveyed to himself and his wife in typical form on a printed deed. Then at the bottom of the printed instrument, we see an addition with some arcane language obliquely suggestive of the desire to create a remainder interest of some kind in his daughter. Now, the deed, I will underscore now and probably as we go along, is of homestead property. It is most conspicuously not signed by the spouse of the grantor. And the language used, if we need that, parties of the second part, plural, witness that in this addition that we're talking about, would strongly suggest that that's what was intended. If it matters, excuse me, that there was some awareness on the part of the grantor that the wife was supposed to sign, needed to sign, to accomplish any result along the lines that he was perhaps intending to accomplish. The court below, nevertheless, held that that created a life estate in the grantor and his wife with a remainder in fee to the daughter who was the subject of this addition I'm talking about. We say it created a tenancy by the entirety in the husband and wife by operation of law and by expressed intention, and failed to create any interest at all in the daughter because it was homestead property, it could not be conveyed, and whatever the intention was, which is certainly subject to doubt in any event, would be frustrated by the statutes. Under the statutes and the Florida Constitution, a spouse can make a deed of homestead to the other spouse with just the title holder's signature. That's a matter of statute, that's clear. Under the statutes and the Constitution, a spouse may not convey any interest in the homestead to any other party without the joinder of the other spouse, and any such conveyance without the joinder of the spouse is contrary to public policy and ineffective.
Why is it not perfectly reasonable to conclude here that the effect of this deed was that Mr. Clemons intended to convey a life estate to himself and his wife as tenants by the entireties, and intended for the remainder interest in the property upon both of their deaths to go to Miss Thornton? I mean, isn't that a reasonable possibility from the language of the will?
Not to me, Your Honor, for several reasons. First of all, the language of the conveyance, until you get to the contradictory and scattered language on the bottom, would not suggest that.
But the person who drafted this was not a lawyer. At least we hope he wasn't a lawyer. And I think we know from the record that he was not a lawyer.
I certainly hope that to be the case. Be that as it may, the intention to express something in some sort of stilted, flowery way should not be allowed to overcome the expression of it in some reasonably clear way, albeit not in legalistic language. What we have here is something that sounds like it comes from one of the double talk artists in show business. All kinds of language that cannot clearly be deduced to say anything in particular except some vague intention to somehow involve the party mentioned, Joyce and Thornton in particular, in the conveyance. The language above makes it perfectly clear that he's conveying to himself and his wife a tenancy by the entirety. More importantly,
but it's also clear that he means to convey some interest to the daughter, right?
I think he tried to somehow involve the daughter in some nebulous way. Yes, I cannot deny, because it's there, it's mentioned. But he had to know that he wasn't effectuating that result when his wife refused to sign. The deed was obviously set up for the wife to sign. If she had done that, he would have accomplished his desired result, if that was his desired result. But significantly, she didn't sign, and he recorded the deed anyway. My interpretation of that is he hoped that something along these lines would happen. I used the term in the brief precatory, that his wife would, upon his demise, if she survived him, feel some moral or ethical or family obligation to do something. But he didn't accomplish it because without her signature, there is no way to convey an interest in homestead.
Well, but there is a way, provided that it's to the two parties by the entireties, the husband and wife. So why isn't it possible that this man actually knew more about the law than we give him credit for, and realized that even if his wife would not sign the deed would still be sufficient to create a life tenancy by the entireties in the real estate, and that upon their deaths, the remainder interest would pass by intestacy to his heirs, and that was better than nothing.
Why would he, unless it was, and I'll follow your course of reasoning, it would be some sort of, I hesitate to use the word scam or ruse on the wife, but he really wouldn't be giving her anything, because by virtue of being a wife, and by virtue of this being homestead property, if she survived him, she had the right to stay there for the rest of her natural life anyway. So what was he giving her? What was he conveying to her if he conveyed a life estate to her? Well, she had that by operation of law.
Maybe he was actually trying to take something away from her.
You could say that, but it is very hard to construe this kind of an instrument, which appears to be an instrument of grant, as something that would be a restriction and a limitation. At least it's very difficult for me. What I'm concerned about...
Gosh, how else do you explain that language? How else do you explain the language, upon the death of the last surviving party of the second part, the property goes to Miss Thornton?
Well, he doesn't say the property goes to Miss Thornton. He says, shall be caused to convey and confirm and assign. Now, I don't know what that means, but it sounds like he's calling for another conveyance. And most importantly, to me, the deed was set up to include the signature of the spouse, which would have rendered this effective. Even assuming that we can interpret this language in some clear way to say that that's what was intended, a life estate with a remainder, he didn't succeed in doing it because he never legally precipitated the remainder.
Well, but it does create the remainder. It's just that it would pass by intestacy rather than by the deed. Isn't that right as a matter of law?
I don't think so.
Assuming he had clearly said, I create a life estate by the entireties in myself and my wife, and upon the death of the last survivor of us, I wish the property will go to Miss Thornton. Would that not be sufficient to create a joint life estate by the entireties with a remainder to the survivors?
I suppose by some, forgive me, strangulated reasoning, but I make the point, and I come back to it, that I did before. That situation existed to begin with. I mean, creating a life estate in his wife is something that's done by the Florida statutes in homestead property. And it's hard for me to deduce an intention to do that. That very, very, perhaps sophisticated intention cannot be attributed to the grantor, I don't think, in this particular case. I think this was a failed attempt to create a life estate with a remainder, at most. Failed because it was homestead property, and in order to convey a remainder interest in it to anyone, the wife had to join. And she didn't join.
So the effort to convey the remainder failed?
Yes, I think so.
And then why doesn't the remainder interest descend to heirs at law?
Because once it failed, we go back to what he did let me say physically, up above in the deed. He conveyed to himself and his wife as tenants by the entirety. What I'm concerned about here, and what I'm arguing, is that I think the trial court exalted what he didn't do over and above what he did do.
To get to that conclusion, don't you have to read out of the deed completely this language at the end?
No, because it's there, but when the wife didn't sign it, and he chose to record the deed anyway, to my way of reckoning, at least as likely as anything else that we posited here today, he said, okay, I want to create the tenancy by the entirety. Anyhow, I'm going to record the deed. Because he had the option, obviously, of not recording the deed at that point when he couldn't effectuate, if we're so supposing, his true intent of creating a remainder interest. Again, I just hesitate so much to concur that we should exalt what he didn't do and couldn't do because the statutes preclude it over what he obviously did do if we read the deed, which is convey a tenancy by the entirety to himself and his wife. I think when he recorded the deed, one deduction we may make is that he hoped something would happen. Maybe he hoped or anticipated that it would be resolved as it's being resolved right now by litigation, unfortunately, because he certainly created an obfuscated situation. Another thing that I would say about the interpretation that has been made is it seems to me unlikely that if all he was doing was creating a life estate with a remainder like this, that he would tie up the property so that for the rest of his natural life and his wife's natural life, they couldn't do anything. If they decided to change residence, if they decided to sell, if the market became wonderful, whatever the case may be. At this point, they've created a remainder interest, if we so interpret it, and they're tied up in a knot. They can't do a thing. I find it difficult to attribute on this flimsy kind of scattered language that kind of an intent to the grantor here.
Mr. Warm, you're down to just over 3 minutes. You had said you wanted to reserve 5, but you're already into that 5. Do you want to go ahead and say what you've got left?
Well, I'll take one more minute and then whatever I have to say. I would say in its best light, he tried simultaneously to create some kind of remainder interest in his daughter, which is precluded by the law and public policy. Do we let the failed attempt somehow prevail? Do we, again, exalt what he didn't do over what he did do, or do we recognize what he did when he recorded the deed, which was recognize that the conveyance to himself and his wife as tenants by the entirety was a normal, regular, and acceptable conveyance, and the other had failed because she didn't sign it, and attribute that to him. If nothing else, I would think if we're going to do anything but go by the statutes and the Constitution and those rules that I'm predicating my argument on, we would need a trial to figure out what his true intention was. The one way his intention doesn't matter, the way I am arguing. The other way, his intention becomes very relevant, and in this twisted state of facts, we ought to find out by an evidentiary hearing.
Thank you. You've got just over 2 minutes left for rebuttal.
May it please the Court, Jim Taylor on behalf of the athlete, Joyce M. Thornton. There are 2 principal issues in this appeal. First, what was the grantor's intent? Second, if, as we believe, the trial court correctly construed the deed as evidencing the grantor's intent to convey to himself and to his wife in an estate by the entirety, a life estate in this property, with the remainder at the death of the survivor of them passing to his daughter, my client, Mrs. Thornton. If that construction is correct, the second issue in this appeal is, as to the conveyance of the remainder, is that legally effective in light of Florida's restriction on the alienability of homestead under Article 10, Section 4 of the Florida Constitution? And secondarily to that issue, if it were legally ineffective for that reason, then how did the remainder pass at Mr. Clemons' death when he died without leaving a will in 2000? As to the first issue, the grantor's intent, Under Florida law, the starting point, and we submit in this case the ending point as well, is an examination of the deed itself, because that in the law is the foremost expression of the grantor's intent. Florida law counsels us in cases like Bronstein and other cases cited in the briefs that we are to look not to certain parts of the instrument to the exclusion of others, but to the instrument as a whole, and to seek to derive from an examination of the entire instrument a construction that is reasonable and gives effect to all of its parts. If there is such a reasonable construction, Florida law tells us that we must follow it, that the deed therefore is unambiguous, and therefore parole evidence of the grantor's intent is inadmissible. The deed therefore stands as the sole expression of the grantor's intent. If, on the other hand, based on the instrument as a whole, there are two or more constructions that would give effect to all of the language in the deed, then we have an ambiguity, and the court must look to parole evidence to resolve that ambiguity and get to the grantor's intent. In this case, as the trial court found, there's only one reasonable construction of this deed that gives effect to all of its parts, and that is that the grantor intended to convey to himself and his wife, in an estate by the entirety, a life estate in this property, and at their deaths, at the death of the survivor, to pass to his daughter Joy the remainder interest in the property. In this regard, it's worthwhile noting, because I sensed a misapprehension of this in the appellant's briefs, that a tenancy by the entirety can be created in any form of estate that can be held in real property. The Florida Supreme Court decision in Matthews versus McCain, which is cited in the briefs, tells us that. It tells us that a tenancy by the entirety can be created not only as to fee simple ownership, but to a leasehold interest, which was the case in Matthews, and also, as in this case, as to a life estate. And in fact, that's what was the situation in the Bronstein decision, the Florida Supreme Court decision in Bronstein, where the deed created a life estate in the husband and wife grantees in an estate by the entirety. So that's what this deed did, I submit very clearly, is to create a life estate in the grantor and his wife with the remainder to his daughter Joy. That construction being the only one that is permissible under the language of the deed therefore is unambiguous, and the trial court was not permitted by Florida law to look to any extrinsic evidence of the grantor's intent. The deed tells us all that we need to know in terms of the grantor's intent. As to the second issue, the legal effectiveness of the conveyance of the remainder to the grantor's daughter Joy. Candidly, it's difficult to square the trial court's ruling with the Florida constitutional restriction on alienability of homestead property. The trial court, in its summary judgment, addressed the first issue that I posited as being the issues in this appeal. What was the grantor's intent? The trial court did not address the second issue, and in failing to do so, may well have erred. It is true that under the Florida Constitution and under Section 689.11, the grantor, Mr. Clemons, could have and did, without his wife's joinder, convey to the two of them as husband and wife any interest he chose to convey in this homestead property. What he chose to convey, what the deed tells us he conveyed, was a life estate interest. Under the constitutional and statutory provisions, however, it is at least questionable whether he could have effectively conveyed without spousal joinder any interest to any person other than himself and his wife. So, to be consistent with the Florida constitutional restriction on alienation of homestead property, I think the correct conclusion in this case is the deed conveyed a life estate interest and then the remainder over. The conveyance of the life estate interest is perfectly valid, perfectly consistent with 689.11, perfectly consistent with Article 10, Section 4 of the Florida Constitution. The conveyance of the remainder over very probably is not, because of the absence of spousal joinder. But the result for which the appellant argues does not follow, either legally or logically. Because there may have been an ineffective conveyance by this deed of the remainder over, doesn't mean that we automatically translate the intended conveyance of a life estate to husband and wife into a conveyance of fee simple. We are still bound to honor the grantor's intent as we can discern it from the deed. The intent...
Mr. Taylor, let me ask you a question. You may have already answered it, but I'd like the record to be clear to the extent it's possible. Are you conceding that that portion of the final order that says that Ms. Thornton owns the property in fee simple is in error?
Yes, sir.
Thank you.
I believe the correct result in this case would be...
I appreciate your saying that. Thank you.
I believe the correct result in this case would be to affirm the trial court's ruling insofar as the conveyance of the life estate to Mr. Clemons and his wife. And Mrs. Clemons had and has, for as long as she may live, a life estate in that property by reason of that conveyance. I believe this court also, however, should reverse the ruling insofar as it concerns the conveyance of the remainder interest to Mrs. Thornton and should remand the case to the trial court for a determination of Mr. Clemons' intestate heirs as being the persons who are entitled to the remainder interest. The lineal, as the statute says, the lineal descendants in being at the time of his death in 2000. And upon that determination, those determined heirs hold the remainder interest in the property. That's our position. I'd be happy to answer any questions.
Thank you, Mr. Taylor.
Thank you.
Mr. Warren, you have 2 minutes and 2 seconds.
All right. I say again, and my final point on this is, if we know that the deed was intended to be signed by both parties, and it was only signed by one and recorded anyway, can we glibly deduce that nevertheless the grantor, in recording the deed, intended to accomplish what he by then knew he could not accomplish because that second conveyance, that addition, was ineffective?
How do we know that he knew he couldn't accomplish that?
Because the deed calls for her signature.
But how do we know he knew that if she didn't sign it, something else would happen? We didn't have any testimony regarding what he believed, did we?
Okay, I'll just put it another way and come to the same conclusion. How can we deduce, how can we predicate a decision on this case, as significant as it is, on the assumption that knowing that she didn't sign, he would have intended to do the same thing, that he wasn't, in effect, surrendering, giving up the ghost on that and recording the deed to create what it ostensibly does until you get down to the bottom, which is a tenancy by the entirety in himself and his wife. We're attributing motivations to him either way, my way or the court's way, that we don't know existed, which, again, conduces to the conclusion that, at best, from the appellee's point of view, the deed is vague, ambiguous, and uncertain, and confounded by the fact that there are legal rules, as has now been conceded, that intercede to obstruct any possible intention you've already derived from it. It's a mess in plain English. But I hesitate to agree with any interpretation that says, again, and I'll stop here, to exalt what he didn't do over and above what he did do, which is, to me, what the trial court has done.
Thank you, Mr. Warren.
Thank you.
Gentlemen, thank you both. The last case